see it from a different perspective, but do you recognise that imbalance that the clients are facing?
Yes, I do, in the sense that it's absolutely real that there is a level of knowledge that the lawyer takes into a case that the client doesn't, and when we're looking at complaints, a lot of it is about there are practical things like communication and delay and so on, but actually when it comes to a complaint, I wasn't told something, or this has come as a surprise to me, there is a legitimate question about what the lawyer told the client at the start and how clear it was during that process and why it was important. So yeah, absolutely, we see it in that context. It manifests in lots of different ways.
And I think I'd just add to that there's a factor that lawyers are habitual record keepers. So if the client's position is, well, this wasn't explained to me properly, the solicitor can always hold up a 20-page bundle of documents to say, well, it was here. And the client is automatically at a disadvantage in those circumstances.
Would you say, Victoria, that this is lawyers forgetting that even at this stage, they should be putting their client's best interests first, but really they're putting their commercial interests first, and they just want to make sure that they've got the signature and then they're going to get their fees?
Absolutely, and the issue that we highlight in the Legal Lexi is the fact that a signature alone is by no means evidence of understanding, and the solicitors generally aren't concerned whether or not the clients have understood. They just want that signature because it creates a contractual obligation. Until you demonstrate that they haven't got informed consent for one reason or another. So yeah, I think it's definitely solicitors putting their commercial practice in advance of their professional obligations.
I mean, we've seen that even broader, haven't we? That there was the Advertising Standards Authority has been having their law firms that basically if you fill out a form online to be contacted by motor finance or something like that, then suddenly they found they've actually signed up to as a client. Well, they signed up as a client, which all they've done is like, ask for more information.
Oh yeah.
It's an interesting question, that, because I'm not entirely sure that those 2 points conflict, the commercial interest, because ultimately you want to get paid. The best way for you to get paid is to have a happy client who understands how much it's going to cost.
But is that because historically, and this is obviously a broad, very broad generalisation, that it was the solicitor knew stuff, we tucked our forelock at the solicitor, we paid nicely, we didn't complain even if we were seething inside, but it's a different world now.
I think, and this is a frequent complaint that I get from clients, there's a failure to recognise that, broadly speaking, when someone goes to a solicitor, it's because something traumatic has happened or is about to happen or potentially may happen to them or to their business. And what the client is going to the solicitor for is for legal advice, and they're not thinking about a commercial contract in the same way as a businessman might do. And frequently what my clients say to me is that they accept that they signed the terms of business. They say, well, I didn't really read them in any detail because I assumed that my solicitors would be, a lot of the time there's an assumption that terms of business are fairly standard industry-wise, which I think we probably know they're not. And there's also an assumption that terms of business won't be detrimental to the client, and often they are, sometimes in some quite subtle ways. But that's the nature of the client who's signing up to these agreements. They're potentially in a traumatic situation. They're not thinking about the commercial aspect of the relationship. They're thinking about what they need in order to help with the divorce or injury or whatever the particular cases that they've gone to a solicitor for. And I don't think solicitors recognise that.
Now, I know the answer to the question. This question is sign up to Legal Lexi. But ultimately, how do you evidence understanding? Aside from
the Legal
signing
Lexi.
up to Legal Lexi.
Is that a question for me?
Well, I guess. Well, yeah. Well, both of you, I suppose.
Well, traditionally, there certainly used to be a requirement for a discussion in relation to terms of business, and I would say that that's still best practice, a face-to-face discussion, pointing out if there are particularly onerous terms in the contract, and that may not be simply down to high charging rates or high success fees. It might be, for example, a contractual term that enables solicitors to deliver interim statutory bills which have the effect of making time run out for assessment, which the courts have repeatedly said are entirely prejudicial to clients. But that particular term is often buried on page 17 in small print, and clients are completely oblivious to it. If that term were explained properly, clients, if they knew they were able to, would shop around and go elsewhere and look for a firm that didn't undertake that particular task of sending out interim statutory bills. So I think best practice would be a verbal explanation, and as with other contracts, pointing out particularly onerous terms, and the more onerous the term, the greater the explanation that's needed to satisfy someone in due course that that's been informed consent to it.
Did you agree with that?
Almost all of it. I think really. I think there's a lot to be garnered from seeing who's in front of you having that conversation, and that's a challenging thing. Although I suppose the generation below ours, if I can be so delicate as to put it this way, a lot of them don't want to speak to a person.
No.
And so those people are both the buyer of the house and the lawyer acting now to help them buy it, and neither of them might have the inclination to say,
No.
"Oh, what does this button do? It's a button. Okay, let's have a conversation." So there are societal attitudinal changes, and it is a challenge for us because we will always say the same things to people. Go and speak to your client about this. If your client's got a beef, make sure they're comfortable talking to you about it, because it doesn't need to be a complaint. If they don't understand something, if you've used the word disbursement and this client has no one, I mean, who's ever used the word disbursements outside of the legal sector? The
Profit costs.
Right, exactly. There are loads of these sort of industry terms that we will throw out, but they don't mean anything to anybody else on the street. So if the client doesn't understand something, make them comfortable raising the issue. And if that happens, these complaints won't generate because that dialogue exists. It might be done by WhatsApp now instead, but however it happens, make sure there is that opportunity, that golden bridge for the client to be able to have the conversation with the lawyer.
I think, this is part of the same point, that with the change in attitude and the change in approach that people adopt to signing things. When we sign up to Facebook, we flick through 50 pages of small print that we don't read and click a button at the end. And lots of retainers now are signed using precisely that method. And I think there should be some recognition that actually we live in an age where people's inclination is just to scroll to the bottom and press go because they want the service. Now, it could well be said that, clients who do that are fools, but that doesn't take into account the fact that they aren't just signing up for a Facebook account or a tin of baked beans or whatever. They're signing up for something that's life-changing potentially, and probably in traumatic circumstances, but still the information these days is just to scroll to the bottom and press go.
You reminded me the other week I was in a hotel and I checked in. There was this huge bit of paperwork to sign, and obviously just being me, You'd be surprised to know that I'm standing there reading it. Right? So,
Oh, did you?
And the woman said, have you got all day? And I went, I've got all night.
No, it's true. Well, obviously, you know, my interest in the Legal Lexi, but the general advice is, first of all, is you remember that the client's costs and generally keep up communication. It's just talk about it. You know, the solicitors are not necessarily keen on talking to their clients about their legal fees, and so they just box it off and hope it'll be all right. It's just just keep talking. But isn't that arguably relatively easily overcome?
Absolutely.
If they follow the guide to a good cost practice and have all the cost information in one place and just send you that?
Okay. There you go. You can see the costs were discussed. I mean, can I? You know, and that's it. Because the process is done. That I've had the conversation, and they might have been brilliant, but they're out bugger all then.
Yeah.
And it's like, what do you want me to do with that? Because your client is saying you didn't explain this really important part of the cost. You didn't tell me about the success fee or how it's calculated. Or I know we did all that.
Yeah.
I mean,
But you can't prove it.
Well, I mean, we need to draw to a close, but if
Yeah.
only someone would come up with a digital system.
Oh, well, thank you. Absolutely.